I'm Andrzej Bojarski, and that was Billy Joel, and it'll be explained in a moment why we have as our special guest Billy Joel as our inspiration for our case study this afternoon. I'm joined this afternoon for this webinar by my colleagues Niki Langridge. Hi Niki, are you there?
I am indeed, hello.
Good to see you, and also Rhys Taylor. Are you there, Rhys?
Hello Andrzej, hello everyone.
Hi Rhys. So today, given that it's a lunchtime webinar, we thought we'd give it a bit of a gastronomic culinary theme. And so you see that we are going to be giving you some scenes from a virtual Italian restaurant inspired by Billy Joel, as you just heard. In a moment, I'm going to introduce you to our case study, Brenda and Eddie, the couple who have been going steady since about 1995, but are now going through a divorce. And once I've given you the facts, you're going to hear from each of us respectively, starting off as a hors d'oeuvre, Rhys Taylor giving you some exposition of the pension issues that are arising now in the context of the COVID-19 epidemic and cases that we're dealing with. We'll then move on to a slightly more meaty starter where I discuss business assets. So after you've supped a little bit of Pinot Grigio with Rhys's starter, you'll be on to a little bit of heavier Barolo with me to go with the starter. And then we'll move on to a main course of Niki discussing Duxbury and maintenance. And she suggested that you're best off opening up a nice cheeky rosé to listen to her with. We do have on this call a Q&A facility. I see at the moment we've got about 80 people there participating, which is good to see. If you do have any questions, please do click on the Q&A button. And towards the end of the seminar, we're going to try and leave a little bit of time to answer those that we can get around to doing. And if those we can't, we'll try and deal with perhaps by way of email afterwards. If it's appropriate to do so. So that's the menu for the session. The dolce, as I say, at the end, the dessert will be the questions. So the foil for our discussion today are Brenda and Eddie, and I'm going to just briefly introduce you to them. So they've been going steady since about 1995. As I said, they're both in their late 40s. They've been married for over 20 years, and they have adult independent children. Eddie and his brother Billy, they run a popular Italian restaurant in North London. Until their separation at the start of 2019, Brenda worked for Billy and Eddie in the restaurant, but she wasn't paid, so no income tax or national insurance contributions were made on her behalf. Now the business runs from premises, a restaurant, which is owned by a small self-administered scheme pension, a SSAS. And the SSAS comprises the premises of the restaurant. There's a small warehouse to the rear, which is let out to a logistics delivery company. And the totality of the premises was valued recently for the divorce proceedings at 5 million. The members of the SSAS are Eddie and his brother Billy, who have equal shares in the SSAS itself. The restaurant itself trades through a company, and that company is owned equally by Eddie and Billy. And for the purposes of the proceedings, it was valued, the total value of the company was 784,000. On the basis of a EBITDA type valuation. Eddie's share after CGT netted down to 352,800. In terms of other relevant assets, there's an inherited property portfolio that Eddie has from one of his uncles. He obtained that before the marriage. It's fully managed, remains in his sole name, but it has provided the parties with an income throughout the period of their marriage and relationship. So, as we said, they're getting divorced. During the course of the negotiations, it was accepted that Brenda's income needs are about 63,000 a year. She's caring for her elderly mother, doesn't intend to work at the future and isn't working at the moment. She's originally from Italy and is considering returning there at some point in the future. Now, the parties did try and negotiate the issue proceedings. They had an FDR on the 10th of January 2020, so earlier this year. They settled the case, as a typical, late in the afternoon. There was only time to make a rose order, so a brief summary of heads of agreement endorsed and approved by the court as a rose order, the order to be perfected and sealed in due course. The key terms of that order for the purposes of our discussions today were that the house was going to be sold, proceeds divided equally, that would meet the parties' housing needs. Eddie agreed to pay a lump sum of 150,000 in respect of the business. Brenda was to have half of the SSAS pension, and Eddie was to pay periodical payments of 5,000 a month, commencing on the 1st of March, continuing until her 55th birthday in December 2028. Now, the order was still being fine-tuned in March 2020 when COVID-19 caused the lockdown. Brenda, notwithstanding that, had obtained a degree absolute shortly after the FDR. Now she wants to bring an application to show cause as to why the Rose Order shouldn't now be perfected and enforced. Eddie, on the other hand, is wondering whether he might be able to challenge that application and whether he should. So those are the issues we're going to discuss as we go through it. Rhys, over to you to deal with pensions.
Thank you very much, Andrzej. So I just would like to talk about pensions through the context of a small self-administered scheme. Those types of pensions create particular problems, and they're defined in the glossary to the Pension Advisory Group as a form of occupational pension scheme typically set up for key employees or directors of a company with fewer than 12 members. One of the key features of a SSAS is that a member of the SSAS will also be a trustee of the SSAS, and that means that in this context, if Brenda was to become an internal pension sharing member of the SSAS, she would become a trustee of that pension and therefore a trustee of the landlord of the business that Billy and Eddie are running. And one can readily see why they may be not very keen on that. So a SSAS quite often will comprise business premises and can act as a sort of a wrapper to be a landlord for a business. It can borrow up to 50% of its assets. There is a very useful appendix to the Pension Advisory Group, Appendix H, which deals exclusively with small self-administered pension schemes. I would commend that to you if you ever have a case with a SSAS. And the message that comes out of it, because of liquidity issues, quite often it's a building which is in the SSAS, you've got to think long in advance of the making of the order, how you are actually going to implement the order. Now, in this case, Eddie thought he had a plan because he was going to sell some property, and he got Billy to agree that he could borrow some money as well in order to, against the SSAS, in order to buy Brenda out so that she could take an external pension share, and therefore she wouldn't become a trustee of the SSAS, and they could all be rid of each other. But because of lockdown now, he can't sell his property and he can't get a mortgage on the business premises for the time being either. So what I thought I'd do is I'd just talk through a few of the issues about the status of the order made on the 10th of January, because pension sharing orders operate in a slightly quirky way sometimes, and then look at how this may be implemented and how the parties may approach the application which Brenda is proposing to make. What I thought I would do is to start with a very helpful pension sharing process chart. This is a chart which is being prepared by Mr. Paul Cobley of Oak Barn Financial Planning, a colleague of mine on the Pension Advisory Group. And I don't think there's a better visual illustration of how pension sharing orders operate than looking at this. So if you start at the left of the slide, you've got the valuation date, and we had a valuation of the SSAS in July of last year, and it was £5 million. Moving right along the timeline, we come to a consent order. I'll discuss in a moment whether or not the Rose order is the consent order as far as the pension is concerned, but you have a consent order, but the pension sharing order doesn't take effect as a matter of law until the later of 28 days after the making of the order or the making of a decree absolute. And at that point, you arrive at something called the transfer day. And at that point, the wife's, because it usually is the wife, her claims are in the bag. She has her beneficial entitlement to the husband's pension, but then going forwards or further right across the slide, there needs to be some time to perfect that beneficial entitlement by creating a formal pension, whether there's at a internal or external share. And the trustees, after the implementation period, will have 4 months in which to revalue the assets and to implement the order. And the day that they can choose, and they can do it on day 1 of the 4 months or at the last day of the 4 months, is called the valuation day. Some people get confused between the valuation date and the valuation day. Always remember, a marriage probably starts with a date, and then one of the last things to happen after it's broken down, sadly, is the valuation day when the pension share is being implemented. But there's just a very short point I'd like to make. Quite often in cases, we're arguing about a percentage here or there, or even a fraction of a percentage that we find in our pension reports. But particularly in a fluctuating time of, as we have at the minute, where property prices and equities are not as stable as they were before COVID, the date on which the pension share is implemented within that 4-month period has the potential to make quite a big difference to the sum of money that the wife will actually receive. So although we sort of argue about these tiny percentages in our cases, actually what happens during the implementation period may well make a more profound difference. And the only thing we can, with a hand on heart, honestly tell our clients is that whatever happens subsequent to the making of a pension sharing order, it won't be precisely as suggested in the pension report. It's simply a best guess. But once we've got to the valuation day, you value the assets, and the wife is then entitled to a share of the husband's pension that he held immediately before the transfer day. And one can see that in this case, with different movements in the property market, that could make a significant difference during that 4-month period. So that's just a visualization of how pension sharing looks. And now let's turn to the Rose order. So we have a Rose order which was made on the 10th of January. We all know that a Rose order is an unperfected order of the court. It is said that it is just as good as any other order that may be made. As I've already mentioned, a pension sharing order doesn't come into force until 28 days after the making of the pension order or decree absolute, whichever is the later. And because Brenda got a decree absolute in January, and she was advised against that, but she went ahead and did it anyway, we know that if the Rose order is the date of a consent order, and for the purposes of the pension sharing order, then it takes effect on the 7th of February. Very briefly, the reason why Brenda was advised not to seek a decree absolute in January is because if Eddie were to die between the making of the order and the coming into effect of the order, Brenda is not a wife, so she's lost her entitlements as a wife under the pension, and the pension sharing order hasn't come into effect. So the client may be coming to see their lawyer to have a look at their insurance certificate in that unhappy event. So do we have an order which has come into effect on the 7th of February? Arguably, yes, you do, because it's an unperfected order of the court. But we must also bear in mind Rule 9.35 of the Family Procedure Rules. That provides that an order for a financial remedy, whether or not by consent or not, which includes a pension sharing order or pension attachment order, must, it's imperative, must, in the body of the order, state there is to be provision by way of a pension sharing or attachment order in accordance with the annex to the order, and there must be an annex. And of course, when we draft Rose orders, no one ever thinks to do an annex on the day. The reason why we have rose orders is that they're complicated to draft, but that doesn't apply usually to a pension sharing order. It's as simple as putting in the details and a percentage figure. So I'm going to assume in this case that nobody thought to get a sealed order at the date of the rose order. There may be an argument, and I've not really seen this developed in any cases, but there may be an argument when, say, it's a complicated order and it takes a few months for the draft to be perfected after the making of the rose order. There's an argument for when you invite the court to seal the order, to say, well, could I have that dated on the date that the rose order was made? Because that is the day when the deal was done, and certain time starts to run from that date. In particular, the time when an order, a pension sharing order, may come into effect. So there's some arguments here about the status of the pension sharing order coming out of the rose order. Should we go on to the next slide? How will the SAS be implemented? As I've already said, the implementation period will start once a trustee has all the documentation at the start of the implementation period. They must have the order, the annex, and a decree absolute, and a relevant fee has to be paid. As I've mentioned, the trustees won't want Brenda as an internal pension sharing member, because she will then have significant influence over the pension, and as that's the landlord for the business, that's something that Billy and Eddie don't particularly fancy. But they've got this real liquidity problem, and this is something which is dealt with in some helpful detail in Appendix H to the Pension Advisory Group report. Eddie thought he had a plan, but events, dear boy, have come to pass, and COVID has scuppered his plans, and he now faces Brenda's enforcement application. What are his options? Well, he might argue that there's simply no pension sharing order in force yet. You need a sealed order to send to the pension trustee, and are they going to accept, well, we had a rose order on the 10th of January and act accordingly? I rather doubt it. And Eddie could also argue against the backdating of the pension sharing order. I don't know how he'd get on with that, but they're arguments he could make. It's also open to the SAS to apply to the pension regulator to extend the period of implementation under the pension sharing implementation and discharge of liability regulations. I'm sure you've all got those on the tips of your fingers at the moment, but it is a statutory instrument that, as we travel through this crisis, we may become more familiar with, because it may simply be impossible in these kinds of circumstances to implement within the 4-month period. And there are provisions which one can readily see might apply in this situation. For instance, subsection 3, the financial interests of the members of the scheme generally will be prejudiced if the trustees or managers do what is needed to discharge their liability for the pension credit within this period. Or at 6, the transferor or transferee has disputed the amount of the cash equivalent calculated and verified for the purposes of the Act. And it may be that the value of the restaurant premises will be contentious in the coming months. Andrzej also mentioned at the outset of this webinar that there's a warehouse which is to the rear of the restaurant, and it really is a separate premises, and it's in logistics and delivery, so we can assume for the purposes of this problem it's doing rather well. And if that was worth what a pension share is worth, providing the parties agreed to this, it might be possible for Brenda to take an in-specie transfer of the warehouse into a SIP, which would be prepared to accept that as an investment. There'll be SIPs out there that would be able to do that. And that would have the advantage of avoiding the liquidity problems that Billy and Eddie are facing. It wouldn't put Brenda in at the table so far as being a landlord of the business, and the order can be implemented. Life isn't so simple as that, though, and it may be that Brenda wouldn't agree, in which case she could insist on her the cash amount being paid. There may well be, well, they would usually be with a SSAS, an administrator, and some of those administrators may be trustees, or even if they're not trustees, they may have quite a large degree of influence as to how the trustees behave and the way in which the pension is managed. And with a forceful institutional trustee or administrator, it may well be that they say, look, the law's the law, and this has got to be implemented, and if you can't do it within 4 months or the extended period of time you've been granted, then I'm very sorry, but you're simply going to have to award Brenda an internal option. So those are some of the arguments that would range around as to how this is going to be implemented, and is it going to be implemented now, or can we wait for a little bit more? There's also the arguments which we've all been talking about over the course of the crisis, relating to whether or not the actual substance of the order could be revisited. And of course, unless there'd been some very prescient drafting on the 10th of January, and we don't have a sealed order yet. And if we don't have a sealed order, then the rebarrel jurisdiction allows the court to change its mind at any time prior to the sealing of the order. And if Brenda is going to take an external share, this may well alter the sum which she's going to take. So if she was entitled to 25, or she's entitled to 50%, I'm sorry, of Eddie's share in the pension, and so she's entitled to 25% overall. And then the premises is no longer worth 5 million, it's now worth, I don't know, 4.5 million or 4 million or something like that, due to the damage which has been done to commercial property valuations. That would significantly alter the sum of money which she's able to take out. Now, you may well say, well, it doesn't matter, does it? Because Eddie has also had to take a hit, and he is no longer sitting on such a valuable asset. So they're each suffering a similar diminution in what they thought they were going to get. We also don't know precisely to what extent the valuation will have changed, and chartered surveyors at the minute are only giving qualified valuations, so it's difficult to be precise. This is not going to be a barter event. A change in value based on the Meyerson approach it makes it highly unlikely that there'd be a barter challenge. But of course, barrel is slightly different, as is thwaite, where you can challenge an executory order. And of course, this isn't an executory order because it's yet to be carried into effect. And as I've already mentioned, trustees can pick their moment in a 4-month period or an extended period if they're granted that by the pension regulator. And that could be tactically deployed, perhaps, by the SSAS in order to pay Brenda a lower amount. So there's a huge amount to think about what happened arising out of that Rose order on the 10th of January. This is very loosely based on a case that I'm aware of. What happened in real life? The court took one look at it and refused to even allow it to be heard. So it didn't even get before a judge, and it's just been spun off to be considered in the mountain of other cases which are going to be dealt with manana. So I'm just going to close with reminding everybody, if they did need reminding, that generally, but in this context in particularly, where there's complexity and where there's difficulties, getting before a judge for adjudications of complex issues, arbitration and early neutral evaluation are options which are readily available to help progress your cases along. So thank you very much for listening, and I shall now hand over to Andrzej.
Thank you very much, Rhys. So it's time to move on to the next course. Time to open up that bottle of Barolo that I promised you earlier, and to discuss the business issues. So just as a reminder, in the settlement that was reached, there was a valuation of the shares of 352,800 net of CGT, and the agreement was that Eddie was going to pay a lump sum of £150,000 to his wife, so roughly about 42.5% of the full net value of the share. So there'd been some discounting that had taken place in the calculation of the settlement. The plan at the FDR had been that he was going to borrow the funds from the business against his director's loan account, and at that stage the business had the cash to facilitate that to a large degree. But then, of course, coronavirus struck, and we can see on the slide the circumstances that changed. So due to the lockdown restrictions, Eddie and Billy had to close the restaurant. They placed their staff on furlough, and they deferred tax payments. So in other words, the business began to accumulate debt. However, about a month or so after the lockdown, Billy had managed to set up an online ordering system. He'd bought a small fleet of mopeds, and they started to use the kitchen facilities to operate as a takeaway delivery business. Billy had himself funded that because Eddie wasn't in a position to do so by injecting £30,000 into the business, and they also took some loans from the various government schemes that were available. The takeaway business turned out to be quite successful, with significantly higher profit margins than the restaurant business had when it was running by itself. And Billy wanted to try and make more of that by buying more mopeds and expanding that side of the business. Eddie had hoped to borrow them funds from Billy and from the business to pay the lump sum to Brenda, but because the business had eaten through its cash quite quickly in the early days of the lockdown, it was no longer in a position to release the funds to Eddie. So in January, despite the lump sum being agreed to, Eddie now found himself in a position where he wasn't able to raise the funds. He pleaded with Billy. Billy offered him $400,000 to buy the shares in total, to divest himself of his interest so that Billy would take on the whole of the business. But Eddie is talking to his lawyers and saying he can't raise the funds now to pay the £150,000 to Brenda this year, and he's wondering what he can do about it. What should he do about it? So the issues that I think arise from that are obviously, first of all, the business valuation. Has it changed? Secondly, if that's the case, can either party reopen the order? But thirdly, and just as importantly, is it in either party's interest to do so? What are the risks they both face? And those are the issues that I'm going to move on to discuss. So let's just begin, first of all, with the valuation and just review how it was done. And in this fictional scenario that we've dealt with, we've provided you with, it was done in the manner that we see most often in relation to a trading business. In other words, on an earnings basis, a maintainable earnings times profit earnings ratio calculation, then with any discounts that needs to be applied to that deducted. So if we break that down, we've got obviously two main components within the valuation. We have the EBITDA, earnings before interest, taxation, depreciation, and amortization, which was adopted by the accountant for the valuation. That figure was deemed to be £224,000 per annum as sustainable ongoing earnings. But of course, an EBITDA figure of sustainable earnings is always based on historical data. It's based on the last 2 or 3 years trading accounts, normally, perhaps weighted to the more recent more than to the ones that are older, but they work broadly on the basis that the history is a good indicator of the future. And with a business such as a restaurant business such as this, with fairly consistent profits year on year, that's a perfectly reliable way of dealing with things. But of course, are those valuation assumptions still realistic in circumstances where the business has had to close down and where there is a significant change in the way it is now trading? I'll come back to that in a minute. Certainly we can see that the 2020 figures are likely, certainly for the first half year, going to be different to what the expectations were at the time of evaluation last year, and we'll come back to that. The second important component, of course, is the PE ratio, the profit earnings ratio, which is slightly different because if you think about it in its most simple term, the PE ratio is, if you like, the number of years that somebody who is investing in that business expects to have to wait before they recoup their investment by way of the profits that are drawn from the business. So in short, it works on the basis that the more risky the venture is seen to be by the purchaser, the sooner they will want to recover their money, therefore the lower the PE ratio. The converse is true as well. The less risk, the higher the PE ratio to reflect the solid nature of the investment, which is why we see with listed stocks on PLC exchanges, PE ratios that are well above 20 times earnings sometimes. But unlike the EBITDA figure, which is specific to this business, the PE ratio is far more related to what's going on in the economy more broadly. It's based on market data for what people pay for similar businesses, which is information derived from comparable transactions, which again means historic data. But it's also influenced by market sentiment. It's influenced by how people feel about confidence in the market and how investors feel. How easily can they borrow money to invest? Are they cautious, in which case the PE may be lower? Are they bullish, in which case the PE may be higher? So supply and demand also comes into it. Are people buying or selling? Third component of the valuation is discount. Now, in this case, the parties were brothers and they'd always traded as partners, so there's no discount for minority holding. But you will recall that the lump sum that was paid was for less than 50% of the valuation of Eddie's shares. So some discounting was applied by the parties in their negotiation to take into account risk and liquidity, so that the shares that were being retained by Eddie equated to a payment to Brenda in cash or a smaller sum. So that's a feature that we'll come back to, because it's important that the risk factor was already factored into the settlement the parties reached. So based on that analysis of how the valuation was reached, we've got a number of questions that arise. Can you reliably revalue the business in the current circumstances? If so, would the valuation be different? Would you, if you were acting for Brenda or if you were acting for Eddie, actually want it to be revalued? And probably most importantly of all, in any event, will the court allow it? So if we go to consider those matters, I think maybe the first important thing to bear in mind is that you do need to look at each case by case. A lot of people are presenting COVID-19 as being entirely economically black news. And of course, for many people, it is. But in every crisis, there are winners and losers. There are swings and roundabouts. And Zoom, which is the platform we're using for this very webinar, is perhaps a very good example of how the COVID-19 lockdown has proved to be very good for certain businesses. If you look at the Zoom share price, it is today roughly 4 times higher than it was in February 2020. So that says a lot about how you need to look at the full picture and look at each case in turn. So if we look at Eddie and Billy's scenario particularly, we know that their core trade was as a restaurant, and we know that's been seriously damaged. But is that damage permanent or temporary? Well, at this point in time, it's really very difficult to say, isn't it? When will normal trade return? We don't know. Will it ever return? We don't know. Even if an effective vaccine is found, will customers return? Will people go out less? Will patterns of behavior have changed? We don't know. They might, on the other hand, of course, party like they never partied before, and there may be a bumper time for restaurants. But again, we don't know. We also know that there's been a slight diversification. There's a new trade as a takeaway. It appears at the moment to be more profitable, which would suggest possibly a higher EBITDA being adopted than that which was adopted before. But the next question is that sustainable? Is that a temporary blip? Or will the diversification be something which, as Billy seems to hope, prove to be a stronger and more profitable business in the future? Bearing in mind it's a new venture, will there be arguments by Eddie that it's a post-separation endeavour, so any changes that have taken place aren't anything to do with what was done during the marriage in any event, and Brenda shouldn't share in that? Might there also be arguments that Billy raises to suggest that because he's put more into this new venture, he should in some way be rewarded by that, by way of the way the profits are shared through the business, or indeed the shareholdings are held? All of that creates uncertainty over the EBITDA figure. But then we also have the fact that the PE ratio is now also very difficult to measure. What's the market doing? Has anyone bought a restaurant since the beginning of March 2019? I don't know, but I suspect probably not. So there's unlikely to be any new comparative data beyond that which was being used based on 2019 transactions. So the difficulty with taking a snapshot view now is that it's going to be based on data which is unrealistic. And if you were working on the basis of, well, nobody's buying businesses now, so therefore it's worthless, that sort of snapshot view is also likely to prove to be unacceptable to a court. The snapshot view is always a difficult sort of approach to take with businesses, because at any point in time, a business value is going to be different for all of the reasons that we've indicated. We know that probably now the PE ratio would be lower than it was in 2019. But is that going to be permanent? Will it be higher in 2021? Again, we don't know. It does really bring into stark relief, doesn't it, the COVID-19 crisis, just what the artificialities that are based, upon which valuations of businesses are based are. The artificial nature of the whole exercise is now very, very obvious. We then also, on these facts, have the offer that Billy has made for the shares of 400,000, which is slightly higher than the valuation figure that was adopted by the SJE. Why is that? Is that because Billy's very confident about the future of the business to suggest that maybe the valuation was too low? Certainly doesn't help Eddie in relation to any arguments that he wants to raise in relation to a reduction in the value of the business, given that that is something he would have to disclose in the circumstances where he was pursuing the matter through the court again. But again, is that maybe a sign that Billy's now being less cooperative and more protective of his side of the business in terms of the development of the takeaway business? So does that to some extent undermine the quasi-partnership analysis that was applied before? So based on all of that, what should they do? Could Eddie and Brenda, either of them, challenge the quantum? Well, for reasons that I'll explain, that's probably difficult to do anyway. But there's also a lot of risk in terms of assessing whether there has been a change and who that change would benefit, because we just can't tell. It might be that it's better for Eddie to be thinking about going back to the court to just look at the time for payment of the lump sum. If the agreement was that he was going to be paying it within 12 months, perhaps that's no longer realistic, and there may be grounds, and stronger grounds on his part, to look to vary that part of the settlement. So we'll turn next to whether the court might even consider a review if either party takes the view that yes, they want to take the risk. Well, there are some different routes to reopen. Rhys has already mentioned some of them. We have, in the case of an order that hasn't yet been sealed, the Barrel Enterprises, or in the House of Lords decision of Riel, the same jurisdiction being applied to revisit the order, reconsider the order. If the order has been sealed but hasn't yet been implemented, in other words, it's still executory, there is the Thwaite jurisdiction that again Rhys mentioned. And then finally, if there's a final order, there's the Barder jurisdiction. Now, in theory, the threshold under both Barrel and Thwaite, as Rhys mentioned, is on paper lower than it is for Barder. But I suspect that the courts are going to be reluctant to just disregard what the cases under Barder in particular say about fluctuations in value and inherent uncertainty, being itself a good enough reason to review an order without more ado than that, because there's a lot to be said for consistency in the approach. But the case law at the moment isn't clear and does appear to suggest there's a lower threshold in relation to those first two types of application than would apply in Barder. That's not a topic we're going to discuss any further today. In fact, the three of us who are presenting today have recorded some webinars on those very topics. You can find them on our YouTube channel, and the link is on the slide there, and these slides will be sent out after the event, so you'll be able to follow that through if you're interested in learning more about that. So we then move on to what I think is a very significant feature of any case such as this, which is the conscious decision of what the parties determined to do in this case. They didn't decide to settle on the basis of sharing the shareholding by transferring shares to Brenda. They didn't agree, in other words, to a Wells and Wells type sharing. They didn't agree to crystallize the value by way of a sale of the business. There may have been good reasons for that, because Billy wasn't prepared to engage in that. Whatever the reasons for it are, they decided to negotiate and allocate the risk between them in a way that meant that Eddie kept the shares and therefore the risk, but potentially also the benefit, and he paid a little bit less than half their numerical value in cash to Brenda by way of a lump sum. Maybe he was being generous because he thought the business was getting stronger. Maybe he made a bad decision. Maybe Brenda was less positive about the business, and therefore she preferred the cash to the risk. We don't really know why they negotiated or what they negotiated, and after the event it's often difficult to understand that. But that's the basis upon which they settled, and it's very important, it seems to me, that given that they could have shared on a Wells and Wells basis, they decided not to. So what do judges say about valuations and risk? Well, I think there are probably three useful cases that is worth looking at in the context of what we're discussing here. The first is those series of cases that arose from 2008 and 9 and the economic crash that took place after the credit crunch. Very different to COVID-19, but a lot of businesses failed and values of the businesses sank considerably in that period of time. Best known case, of course, is Meyerson and Meyerson. It wasn't alone. There were half a dozen that were reported around about that time with similar provisions. Meyerson was a Barder appeal, which is perhaps significant based on what I said earlier on about the higher threshold. It was based on Mr. Meyerson coming back to the court to say that the business which he had agreed he was going to retain and pay significant £1 million lump sums to his wife in relation to had significantly reduced in value. The point the court made was that valuations are inherently uncertain. They can be volatile. And so that was not given as a good enough reason for why the court should reconsider under BARDA principles the change in value of his assets. Indeed, all of those cases that are reported from that period of time based on fluctuations in value were unsuccessful in terms of the application to reopen. Versteeg is a more recent case, one of two more recent cases, which are essential reading, I would suggest, for any of you who are dealing with a case with business assets involved. Versteeg actually covers a range of different issues that the Court of Appeal gave some valuable guidance about. But in terms of what we're discussing here, perhaps most importantly, is the analysis of Wells and Wells. In that case, it was argued by one of the parties that Wells was a fairly unique case, and generally speaking, it would be very unusual for the court to make an order which shares a business shares between the two parties in specie, rather than allowing one to keep them and the other one to receive a lump sum payment for them. And the Court of Appeal in Versteeg rejected that idea. They didn't say that Wells was a unique case or a very special or exceptional case. It was a principle that could apply in more cases. And the reason I highlight the case is because not only with the sort of situation we're talking about with Eddie and Brenda in this scenario, not only in that sort of scenario, but in more general cases dealing with businesses at the moment, given all of the difficulties that there are in valuing those assets, one can see that the Wells and Wells approach may well find far more favour with judges when they're faced with real difficulties in trying to establish what the value of a business is, unless the parties have agreed otherwise. So we may well see more of that whilst uncertainty is live. The second case is Martin, which again makes a lot of the same points as Versteeg, but goes on to also accept the proposition which many of us probably thought wasn't that controversial at all, but Mr. Justice Mostyn took a different view at first instance. That is the proposition that not all assets are the same. And risky assets in the nature of a business are generally regarded as being worth pound for pound less than a copper bottom safe asset such as cash or real estate. And the Court of Appeal fairly roundly rejected the idea from Mr. Justice Mostyn that once you've got a valuation of a business, risk is built into it, and you can take the valuation of the business as being worth pound for pound exactly the same as cash in the bank. The court has said you do need to draw an analysis in every case. And of course, in the context of Brenda and Eddie, that none of these cases particularly help either of them in trying to seek a reopening based on changes in the business, because although what has happened is unusual and certainly not what they expected, it is a fluctuation in value which they could have avoided by way of a Wells and Wells sharing. So does that mean that COVID will never be a BARDA event? Well, I suspect that's not right either. But I think you need to be looking at cases where the changes that have taken place are so significant that they've effectively resulted in a collapse of a business or a cessation of a business that was otherwise anticipated likely to continue for a longer period of time. Brenda and Eddie's case doesn't appear to be in that same category. We've got fluctuations, but not a complete collapse. Finally, just a couple of last points to make, because many people will try now to take advantage by taking a snapshot view of valuations, because businesses are now difficult to sell, because the PE ratio may be difficult to apply. It may be tempting for people to say, well, at the moment, my business is worth almost nothing because I can't sell it. It's worthless. But we can see, although on different sorts of facts, a couple of decisions where the court has rejected the idea of an artificial snapshot view. So Haskell and Haskell, a recent case where Mr. Justice Mostyn took the view that the husband, whose assets had for sure dipped dramatically, and he was in what was described as the nadir of his financial resources for a period of time. The court took the view he was a wealthy man previously, he was a successful businessman, he was going through a dip, but over the course of the next 2 to 3 years, he was likely to come out of that dip and become a very wealthy man again. So the court took the view longer term rather than taking a snapshot view. And again, on different facts, again, in AW and AH, a non-disclosure case largely, it has to be said, Mrs. Justice Roberts also declined to take a snapshot view, but adjourned claims because of the expectation that the position would be there in the future. So although they're not COVID-related cases, I think there's a lot to be learned from those cases to apply to those cases where you're dealing with a business. So I think the conclusion we could draw from all of this is that business cases are very difficult at the moment, both those that have been settled and you're looking to review, but also those you're dealing with currently prior to a final order being made. I think Wells and Wells type division is more likely to now come up more often. And I do certainly suggest you dig out Versteeg and Martin and remind yourself as to what the Court of Appeal has said in each of those cases. So that's enough from me. I'm now going to invite Niki to crack open a bottle of rosé and deal with Duxbury.
Thank you, Andre. Well, of course, by the time you get to your bottle of rosé, after you've already cracked your Pinot Grigio and your Barolo, I suspect you're about ready for a siesta. Hopefully, you can delay it for 15, 20 minutes or so. Well, I start with a little bit of what I suspect for most of you will be refresher in terms of Duxbury, and then I'll move on to look at it in the context of the scenario we've been looking at in terms of Brenda and Eddie. So first of all, right back to basics, what is Duxbury? It's a fund. Now, I'm going to get the joy of playing government scientist and say, next slide, please, to Andre, because he's controlling the slides. Thank you. So what is it? It's an actuarial calculation designed to identify the capital sum required to meet an income requirement in lieu of periodical payments. I can't stress strongly enough how important it is to always bear in mind when you are advising a client about what you are trying to achieve in terms of a Duxbury, that you never sell it on the basis of an income for life, a guaranteed sum, or anything like it. It is very much designed to replace effectively periodical payments, and I'll come on in a moment to look at why that is so important to have at the forefront of your mind, and also the forefront of any advice you're giving to a client in terms of looking at capitalisation. So what do you need to know to be able to produce a Duxbury? Well, you need 3 facts, and only 3 facts really, about the recipient of the fund. Firstly, his or her age. Secondly, his or her gender. And thirdly, the net income requirement. And armed only with those 3 facts, you go to what is at the moment table 9 in at a glance, or if you want to be a little bit more sophisticated, at e-glance, or if you want to be entirely bespoke, where you will need more facts and figures, you then go on to capitalise. But certainly just for the tables in at a glance, those are the 3 facts that you need. And why do I say it's important to have at the forefront of your mind what Duxbury Fund is designed to achieve, as opposed to the perhaps common misconception? And that's because what a Duxbury Fund is not, next slide please, it is not a guaranteed income for the rest of somebody's life. It is not something that somebody who would be an IFA, somebody who would sit down with an IFA would produce. Financial planning would require, of course, because of its regulated nature, it would require the advisor to take into account not just those 3 facts that you could simply input into the tables in at a glance, but it would require the advisor to know the client's approach to risk, other factors affecting life expectancy, such as whether they're a smoker, their lifestyle, do they do bungee jumping, scuba diving, parachuting, motor car racing, all those other things which would, from an insurer's point of view perhaps, or from somebody advising in this sort of context, would be highly pertinent. And so don't feel any anxiety whatsoever. You don't need at this point in time to amend your Know Your Client or Know Your Client's form, a spouse form. Those are matters which fall under the ambit of a regulated advisor in terms of financial advice. They're not something that would be taken into account or could be taken into account in the context of a Duxbury Fund. And that's why something which is quite often, if you send a client off with the figures and facts for the Duxbury, they will quite often come back with an IFA telling them, and then them in turn relaying to you that this just doesn't stack up, that this isn't going to work. If you look at it in comparison to an annuity, you see straight away that it doesn't achieve what it says on the tin it's meant to achieve. Well, that's because it's a misunderstanding of what it's designed to achieve. A simple example, if you make the comparison with an annuity, as was done in a case called AR&AR, which we'll look at in a moment, the stark contrast between a Duxbury and annuity was such that to achieve the same sort of income under an annuity required a fund of 6.8 million. The exact same Duxbury, almost exact same Duxbury, was 3 million. So that flags up straight away that we are not looking at something that is going to give somebody a guaranteed income for the rest of their life. So what are we looking at? We're looking at effectively next slide please, a series of assumptions set out very clearly and summarised in JL and SL number 3, the post-judgment amplification case, one of those cases we all for some reason remember better than most, set out there by Mr. Justice Mostyn. We are looking at effectively 10 facts: uniform income yield, uniform rate of capital growth, uniform rate of inflation, consistent regime of taxation, bands allowances increasing in line with inflation only, a constant level of drawdown in real terms, a consistent rate of churn, i.e. the realisation of the capital gains other than to fund the expenditure, and that the recipient will survive to precisely the expected average of her contemporaries or his contemporaries, and B, or become entitled to a full state pension, and which will increase in line with prices, and while at that age the state pension payable will not alter in the meantime. Well, we know, don't we, that virtually every one of those assumptions will simply not stand the test of time. Underlying, even within those assumptions, are effectively 3 financial predictions: that the average income yield will be 3% per annum, that the average capital growth will be 3.75, and that the average inflation will be 3%. None of that, we know, will be achieved. And we know, therefore, that in fact, this will not work out. And I'll come on in a moment to some of the quotes from the judiciary that make that absolutely plain. But what, of course, is not, what is being aimed at, if you like, this replacement of periodical payments, is effectively a balancing of risks, looking at not just the risk for one party, but the possible risks and benefits for both parties that are weighed up in the calculation of a Duxbury. So for the payer, for example, the risks include that, and I'm going to use, I've said wife, of course, that's slipped into autopilot there, using wife and husband as, I have to attempted to start with payer and recipient. I've automatically gone into default mode of saying the wife's the recipient. But let's say, for example, she dies, remarried, or other circumstances would justify the cessation or a reduction in the level of maintenance before the assumed date of death. Then in those circumstances, it's obvious, isn't it, that the payer has lost out. Equally, from the recipient, I pause and correct myself and don't say wife, but from the recipient's perspective, they may live longer than the expectancy, than their life expectancy, but they are also insulated against, for example, the payer's future loss of employment or the payer's earlier death than expected. So all of those factors are weighed in considering a Duxbury that is far more than simply saying it's going to give you a certain figure for the rest of your life. It's going to effectively replace conceptually and actuarially all of the factors, all of the risks, based upon those various assumptions that a periodical payments order would bring to a financial settlement. And so what we have been told repeatedly by the judiciary, that it's absolutely not going to achieve what it's said, what is suggested by some, that it's going to give you a certain life. What we know with Lord Justice Wall in Fielden and Cunliffe, as has been said more than once, the only thing that one can be sure about a Duxbury is that the figure is likely to be too high or too low. It's, however, a useful guide. And again, Lord Justice Ward in B&B, the only certainty is that it will not happen as we have predicted. Having said that, it has become effectively the industry standard. And I'll come on in a moment to consider perhaps some options where it may not be appropriate. But by and large, it is in fact certainly the starting point, and in many instances, in fact, the end point. Lord Justice Ryder in H&H makes it absolutely clear, where he says, and very firmly of the view, that there is no industry standard, even less an acknowledgement by the family division judges that there should be such a rate. However, he then goes on to say, in summary, it's not wise to assume that because the Duxbury Committee of the opinion, in the context of their calculation, 3.75 gross is achievable over the long term with a cautious investment strategy, and that the parties will agree that this rate is applicable to capital funds that are not to be amortised on the particular facts of the case. However, if they do agree, or if the judge decides the assumption is valid on the facts of the case, I cannot, for my part, see how objection can be taken. If they do not, then the rate chosen by the court should be reasoned. So although it's clear we don't have an industry standard, nevertheless, if a court is going to adopt another rate, it needs to be reasoned. That perhaps more accurately is summed up by Mr. Justice Mostyn in JL and SL, which we looked at earlier, where he says, of course, there's no standard rate in the sense that the economic assumptions underpinning the formula are written in marble, from which there can be no deviation. But the Duxbury tables are used in countless cases. Their underlying methodology and assumptions are widely accepted as the usual starting point, and where there is no countervailing evidence, the usual finishing point. In that sense, they do represent an industry standard. So it's sensible, reasonable, and logical then to always at least start with a Duxbury figure and consider whether or not there are any unique factors in your particular case that would suggest a different model or countervailing evidence, to use the phrase of Mr. Justice Mostyn, would be appropriate. When do you consider then another model? Next slide, please. You consider it when, for example, you have what is often identified as being the Duxbury paradox, which is that you have, for example, an elderly recipient after a long marriage, which effectively requires then a smaller amount of money to fund an income stream for the rest of their life. And the classic example of that is a pretty old case now, 1999 case by Mr. Justice Singer, where he was dealing with, in those circumstances, in fact, and this is why I really shouldn't have fallen into the error of saying husband and wife in this particular instance, because in this case, it was in fact the husband who was the recipient of the fund. He was 79 years of age, the wife was 76 years of age. The marriage had lasted for 50 years. And I probably should pause to say, of course, this case arose, I think, between the Court of Appeal and the House of Lords in White and White. And I suspect, and this is one of those great examples of timing being everything, I suspect that if this case had been decided just a few years later, the outcome for the husband would have been far different. I suspect the yardstick of equality would have loomed even higher. But in any event, wife had set up and established and was running a very successful nursing home business, turning over something like £1 million or so. The issue was, at that time, what should be the capital figure effectively to provide the husband with his income needs for the rest of his life. And in fact, having looked at, in some extent, in some detail, the actual impact of looking at life expectancy when you're dealing with an elderly person, such as this husband, Mr. Justice Singer came to the conclusion that it was utterly unfair and utterly dangerous, in fact, to saddle the husband effectively with an expected life expectancy, with a Duxbury fund based upon his life expectancy. And he goes through, in the body of the case, he goes through the illusion, if you like, that if you say to yourself that he's got a life expectancy at 78 of 7.2 years, when he gets to 85, of course, his life expectancy is now suddenly 4.8 years. And if he survives to 89, he's now expected to live another 3.7 years. And so the danger with Duxbury for this sort of client is that you have effectively, with imminent expiration of fund and mortality, you have a very high risk, or somewhat higher risk perhaps, than with a younger client, that the person will not achieve the desired income stream, because effectively in both situations where you have an elderly client, or similarly where you're looking for a comparatively low income, there's a higher risk of effectively not being able to hedge against the ups and downs of the economy, to balance out the various investment and appetites for risk, etc. And so the risk in these sort of situations is that the person will actually find themselves running out of funds if they live longer than their expected life expectancy. So what other models can you use? Well, one of the rare examples of a case where the courts were willing to consider something else, or certainly if not willing to consider it, willing not to disapprove of it being used. Tattersall and Tattersall from 2018, Lord Justice Moylan was, although somewhat perhaps surprised that Duxbury hadn't been followed, he made the point that although one would expect to see Duxbury being used, it wasn't necessarily an error of law to use something else. In that particular instance, it was the Ogden tables that had been used. So is clearly Duxbury is a starting point. Next slide, please. And that has been stressed over and over again in pretty countless authorities, starting with, well, not starting with, but going back as far as 1996 with Justice Holman, rather. I cannot stress too strongly that I regard Duxbury as a starting point, a guide, in no way determinative of an appropriate capital award in lieu of maintenance. So it isn't necessarily the end. It may be the end in terms of the model. It may be that we don't have to look necessarily at other models, but we certainly aren't, or certainly the judiciary are not absolutely high-bound into adopting just Duxbury with no other up or down, uplift or downward consideration. An example, Mr. Justice, as he then was, Moylan, in AR and AR, the case I referred to earlier, where they considered the model of looking at, in fact, the contrast between Duxbury and an annuity. Total assets in the case 21 to 24 million, almost all gifted or inherited by the husband, so flags up this is really now a needs case. During the marriage, income from the inherited resources have been used. Wife had sought an award based upon the annuity. However, Mr. Justice Moylan decided that although the Duxbury would provide a figure of 2.5 million based upon an income stream, an income need of 115,000, that didn't provide what he considered to be a perfectly reasonable added extra of some discretionary expenditure that wasn't in the wife's annual budget. And so to allow for that expenditure, he enhanced the lump sum for income to 3.2 million. So effectively adding about 700,000 to the Duxbury. But he made a very strong and important point, because often when we're looking at Duxbury, we're looking at a time when we are seeking effectively to capitalise an existing income stream. Not always, but certainly on some occasions. And so it's important to take on board that there is a difference in terms of the scope for departing from Duxbury between cases which are determined on the basis of Section 25, i.e. when all matters are being considered. The courts have been pretty clear at that point. It's very, very important for the court not to effectively just simply adopt the Duxbury figure, but to have a broader discretionary consideration of all the Section 25 factors, set against if you are simply capitalising the income stream. And this goes to, this is Lord Justice Thorpe and Pearce, endorsed by Lord Justice Wilson in Vaughan and Vaughan, where they both effectively say that the discipline that is necessary to safeguard against a further capital division between the parties to reflect the factors were not foreseen must be avoided. Effectively keep to the simple, certain and predictable method of capitalisation that Duxbury provides, so that there is really a very narrow gap to depart from a pure Duxbury calculation if you are considering capitalisation, as opposed to if you are considering the first bite of the cherry, so to speak, in terms of the Section 25 exercise. A couple of tips when you are looking at Duxbury's. First of all, don't forget, and particularly where you have, as many people are in this situation, a relatively unsophisticated investor, don't forget that there will be costs of managing the fund. And if you're looking at something along the lines of 1% out of £1 million fund, that's going to be £10,000 per annum. If that isn't factored into the wife's needs, it's going to have an impact upon the figure that she actually has available to her when she comes to actually start to live on her Duxbury fund. Secondly, consider underlying assumptions, and you almost need to go back to the list in JL and SL and consider in each of your individual cases, does each of these assumptions hold good? Now, having said earlier that there's very little scope to depart from Duxbury, that it really is the industry standard, it's certainly the starting point and often the end point. If you can, of course, if you can show that there are good reasons to depart from the Duxbury formula, then they will, of course, be taken into consideration. And certainly to some extent, you have to take those into account. And in many cases, it'll be far more appropriate to have a bespoke calculation under the capitalised programme, for example. And thirdly, don't forget the idea of clawback. It seems to me that actually in recent times, we've almost let that memory of Dixon and Marchand fade a little bit. But it was certainly a wake-up call for those of us who were around when it was reported that if somebody marries in the reasonably soon aftermath, what many of us perhaps might have thought was a barter event, or possibly something that at least justify revisiting, was found not to be. And so if you are concerned that in fact it would be appropriate to have some sort of clawback available, then in those circumstances it may well be sensible to factor in some sort of clawback, perhaps with a time scale, X amount of the fund within X number of years or Y number of years. So how does all that take us, how does all that impact upon Brenda and Eddie? And I'm not just going to look at Duxbury, but I'm going to look at general income issues that arise in the context of Brenda and Eddie. So firstly, can Brenda increase her level of maintenance? She's come to you and she's asked you, look, I've heard my nephew is a moped driver. He's telling me, he's reporting that this business is now highly profitable. It's making more money than it ever did when it was a restaurant. It's making a greater level of profit. Can I please have more maintenance in light of it? Increase the level of my maintenance. Well, the simple answer to that is no. We know that now. It's very clear. It's about looking at her needs rather than Eddie's income. And very clearly stated, Waggett and Waggett, C&C, and particularly in this context, O'Dwyer and O'Dwyer, Mr. Justice Francis, the income stream from the husband's business is not matrimonial property. Future income is not up for sharing. So I think that's a pretty straightforward answer to Brenda, that no, she cannot increase her maintenance just because Eddie is now making a greater level of profit. She's tired at the end of the day when they're negotiating the Rose order, the Rose terms. She can't remember how they came to work out £5,000 a month when everybody had accepted her income needs for more than that, 63,375 rather than 60,000. Well, you'll recall, of course, Waggett going back to H&H, referred to H&H, that case when Lord Justice Ryder makes clear it's not the industry standard, but if you're going to give another figure, you might want to think about having some sort of evidence or a rationale to explain it. So it's effectively the figure, the non-amortised income that could be achieved from the £150,000 that Brenda has received in respect of her share of the business. So Waggett, quite clearly, there's a complete discretion. However, 2.25% of 150, there's the answer, 3,375. Why is it not being amortised? Well, given that Eddie is still earning, still generating income going forward, perhaps that's the reason it was felt fair and reasonable at the time that in fact Brenda would not be expected to amortise her capital, but just in fact draw the income stream in relation to the return that was coming on the investment of the £150,000. What figures would arise if you were considering the Duxbury? Well, of course, it's perhaps something of a misnomer to say it would be a Duxbury, because a Duxbury would normally be considered to be a lifetime capitalisation. So you'd have to be thinking, in fact, in terms of the specific period, thinking about the fact that there was a pension share. I'll come on in a moment to look at that a little bit more. But in terms of the actual looking at capitalisation, again, go back to those facts and those assumptions that are made and set out earlier in JL and SL. What, in fact, which of those boxes effectively can we tick, which can't we? Well, we've had flagged up that Brenda was not, although she was working, she wasn't paying tax and national insurance contributions on her income. So we have to immediately question, not necessarily, but it's not necessarily fatal, but it may be, and it should flag up and set alarm bells ringing, that she may not in fact have qualified for state pension. So you'd instantly be wanting to check, does she qualify for the full state pension? Because of course a Duxbury is going to assume that she's going to receive that full state pension in due course. What about the move to Italy? Well, we know, don't we, that everything in Duxbury is based upon living in this country. So if she's going to move to Italy, very many of those assumptions are going to be utterly inappropriate. She's going to be subject to Italian tax. The Italian cost of living will be more relevant. Italian inflation will be more relevant, and that may well be quite significantly different. And again, there'll be a question mark over Italian housing market. Would that in fact help if she could in fact buy something cheaper? and release some capital. So all of those factors would become something that would be worth exploring with either Brenda or Eddie if there is going to be a move to Italy. And it would be certainly, I would consider in those circumstances, it would be appropriate to argue perhaps for some sort of departure from Duxbury, to take advice perhaps from somebody au fait with the Italian financial markets, and consider to what extent therefore there should be some sort of adjustment to the Duxbury model that would make this fairer in terms of the future for Brenda. What if, so actually Italy in fact wouldn't matter so much, but bear in mind that Italy, very similar sort of economic climate to ours, very similar sort of cost of living to ours. But if somebody is, for example, going to be going to somewhere like Hong Kong or Singapore, where the cost of living is 22-25% higher than here, then this could in fact be something that you really do need to take into account if you're considering a capitalisation. You have the quote that you'll need to deploy F&F, Duxbury calculation rate of return, Mr. Justice Holman again, and he stresses that on the particular facts, it can be justified that there be a higher or a lower assumed real rate of return, and expert evidence in support thereof. So there's the relevant quote. Brenda's mentioned the fact that her IFA that she has gone off to see initially is very concerned about the fact that her maintenance order was termed to end when she was 55 in 2028. And this is almost the sort of the gold star, the extra house points I've obviously been homeschooling too long moment, because of course what most of us should hopefully be aware of is that there is government policy that will keep the gap between state pension age and the age at which you can draw pension under a private pension scheme about 10 years apart. And so when the state pension age moves up to 67, so the private pension age will move up to 57. And that currently is timed to happen in 2028. So if, in this case, Brenda's representative had agreed to a term order to her 55th birthday in 2028 with the expectation that she would then be able to draw funds from her SSAS, there would in fact now be a potential negligence claim because she would be having something like a 2-year gap. And we'd certainly be now looking at whether or not that was a 28(1)(a) bar or not that had been agreed. So I hope that is a little bit of a refresher and highlights some of the matters that you have to think about when you are considering a Duxbury and considering some of the issues that would arise in a case such as this. I think we're now going to move on to some questions and answers, and I can see some popping up at the bottom of the screen, but I think Rhys is going to take the first one, certainly.
Yeah, thank you very much, Niki. Can you hear me?
Yes, I can.
Really good, yes. Right, so the time's nearly up, ladies and gentlemen, so we're just going to cover a couple of questions. And one that's come in is about mortgage holidays, which are being granted during this period. And if someone has perhaps in January given an undertaking to pay the mortgage pending sale of the property, do either of you have any views about what impact that should make and how that might alter the final reckoning of an order?
Well, I mean, it depends how it's phrased, doesn't it? But if there is an indemnity to pay the mortgage and it hasn't been paid, then strictly speaking, on the face of the order, if that's how it's been drafted, the indemnity can be applied, can't it?
Yes. But what of the fact that, you know, in some circumstances, it's an undertaking, do you apply back to court for release from that undertaking, or is it a given?
Well, the reality is, in most cases, it probably isn't going to make enough of a difference to make it cost effective to do so. But it depends, I suppose, how long it lasts, doesn't it?
Yes. Two pension type questions. One was, should we fill out pension annexes when we fill out a rose order? It's often the case that the timing isn't going to matter. The timing in this case might have mattered, I suppose. I think you'd need to think about it on the individual facts of the case, but certainly in order to have an order which you can present to a trustee to start the implementation period, You need an order, even if it was a scrappy order, and an annex which is sealed. Another interesting question which has come in relates to if somebody is going to call an IFA or somebody to challenge the Duxbury Assumptions, should that expert be brought to court and cross-examined? I don't know, Niki, do you have any views about that?
I mean, it depends, obviously, doesn't it? But I think if it's a consent order, I can't imagine that a judge would be too exercised by whether or not somebody was using something other than a Duxbury formula. But I think if you're in a contested hearing, then I think it would be something that you could consider challenging if you're for the paying party and the figure looks more generous than the Duxbury, or vice versa, if you're the recipient and the figure's lower. Yes, I think it really does. Any departure from Duxbury, I think the simple principle has to be, it's going to have to be justified if you're in contested litigation. And so if somebody has very good reason and backed up by evidence for saying that Duxbury's wrong in this particular case, I think the court should take it into account. But whether or not they will necessarily adopt an IFA's assessment, or whether or not there'll be some other judicial determination of the point, is something of a moot point. But yes, it can be. I mean, I'm thinking of one, there's a pretty clear example of somebody who had health issues, and there was a huge debate as to whether or not it was appropriate to take Ogden tables in those circumstances rather than take Duxbury. And in fact, for various reasons, the court ended up using Duxbury even in the context of somebody with care needs, where you may think that Ogden may have been more appropriate.
Just chipping in there on that question, I've on occasion had an IFA, particularly with older clients, where the Duxbury Assumptions perhaps haven't got time to play out in the same way as they would with the younger parties, and I have had experts instructed to challenge the Duxbury figures, but in those instances they haven't, in the cases I've been involved in, the experts haven't been called to court, and the reports have been very thorough. One can see the rationale as to why a different figure is being posited. It's being contrasted to the Duxbury figure side by side, and then effectively it's in the cases I've been involved in any event, it's been a question of submissions rather than cross-examination. But that's not to say that that couldn't happen. Well, ladies and gentlemen, it's
Rhys, there's just one more. There's one more, I think, for me. There's a question just asking to clarify what the Versteeg case decided. Maybe if I didn't make it clear enough, the important point is this, from the purposes of what we were discussing today. In Versteeg, the wife wanted a lump sum in relation to the shares in the business that the husband ran. The court found, at the first instance, it couldn't reliably value the business. It was just too difficult to put a reliable, safe valuation on it, and made a Wells order giving her a shareholding against her wishes. And she appealed that on various grounds. And the Court of Appeal said, well, no, in these circumstances, because they couldn't reliably value the company, it was appropriate to make a Wells order, and it didn't require the consent of the parties, and it didn't require special circumstances beyond that. So I think in the current climate, where valuing businesses is difficult, Versteeg becomes really very important.
Yes, thank you very much, Andrzej. So I think time's up now, folks. I trust you've had a good lunch and that we've been able to entertain you and keep you awake for the last hour or so. If there are any further queries that you have, our contact details are at the back of the slides, and the slides will be sent out